So NAR engaged in a quite lengthy series of discussions with the FTC to try to get you out from under the Mars rule. And luckily in July, they finally announced that there would be a stay on enforcement of the Mars rules against real estate licensees in certain situations. And basically the stay was pretty broad. It basically said that if you are a real estate agent, you are licensed, your license is in good standing, you're complying with your state licensing laws, and you're acting in your capacity as a real estate licensee and trying to sell the property, that you will not be subject to the disclosure requirements or the ban on upfront fees. So I think most of our members are going to fall into that category. So what that means is, again, if you are the listing agent, you're trying to sell a property, it has to be, it's going to be a short sale. You don't have to do any of the 3 disclosures. You could collect, perhaps, some of you I know have a flat fee portion of your commission, and you may get paid that up front, and then you get paid another percentage upon the sale. Some people have that business model. That would now be permitted under Mars, again, as long as that's part of your listing service in handling the sale of this property. Now, if you are a real estate licensee, and I know there are some of those out there that are offering your services as a short sale negotiator, and it's not on just your listing, you're offering this to other real estate licensees, then you will be subject to Mars because it's not your listing. So you're not offering that as part of your listing services. So those people will still be subject to Mars, the disclosure requirements, and also the prohibition against receiving an upfront fee. The other thing that the stay clearly stated, though, is that you will still be subject to some action under Mars if you engage in misrepresentations. So if you were telling a seller, hey, this is a short sale, you are not to contact your lender, everything needs to go through me, I'm going to guarantee that you're going to get this short sale approved, or you make other statements that are false, then you're going to have some problems under Mars, and probably as well with the Division of Real Estate on that issue. Okay.
And the purpose of today is to let you know what those seller financing options are. The first one is a purchase money mortgage. You can only use a purchase money mortgage where the seller owns the property free and clear of all liens. It really doesn't work if they have a mortgage on the property. This is treated exactly as if the seller is the bank. The seller deeds the property to the purchaser signs a note, the purchaser signs a mortgage, the payments are to be made to the seller, directly to the seller. It's up to the seller whether or not he wants to pay the taxes and the insurance, just like you would have on a normal mortgage loan. The nice thing about this financing for you as a real estate agent is under most of your listing contracts, the commission is due when title is transferred or when you have a ready and able purchaser. So somebody comes up with a brilliant idea that they're going to do a lease purchase. And that lease purchase is going to be for a period of 2 years. Okay? It's invalid. It's invalid. A contract to purchase real estate must be completed within a year. And yeah, I hear all okay. It's amazing. I was talking about this at a continuing education for attorneys, and it was this same reaction. Oh. It's like, excuse me, people, but I think I learned that real property law back in 1968 when I was in law school. A contract to purchase must be completed within a year, and you can write down the code section in case one of these attorneys that didn't know that says, oh, where's your authority for that? Try Ohio Revised Code 1335.05. Ohio Revised Code section 1335.05. And Kentucky, and I'm sure there's no Kentucky realtors here, but Kentucky has a similar statute. Contract to purchase for real estate must be completed within a year. So you can't do a contract requiring that the buyer purchase the property for longer than a year. If it's a lease purchase contract, it can't be for longer than a year. Basic information for a lease, and it's got on it whether or not it's a lease with option to purchase or a lease with obligation to purchase. It's got all of the terms that the buyers and the sellers agree to. There's a similar form for the basic information for a land installment contract. And when you enter into the purchase contract that says that you're going to use one of those three vehicles, you fill out the form and have the buyers and the sellers agree to all of the information included in that form. That form, along with the contract to purchase, goes to the attorney that's preparing the document. And then he puts that information within the framework of the legal document that's going to be executed between the buyers and the sellers, the land installment contract, the lease with option to purchase. On a land installment contract, again, the seller remains entitled, so you've got all of those issues that you would have with the seller remaining entitled on a lease with option to purchase or a lease purchase. The bankruptcy issues, the credit issues, etc. The law is a lot clearer, though, as to a land installment contract, how it relates to and how it's handled in a bankruptcy action. You're usually going to not lose the benefit of your down payment, etc., because of the bankruptcy laws, whereas because a lease or a lease with lease purchase or a lease with obligation to purchase or option to purchase, those transactions are treated differently in the bankruptcy court. So I always think that a land installment contract is a much better vehicle to use for this type of a transaction than a lease with option to purchase or a lease with obligation to purchase. The only drawback with a land installment contract is that if the buyer, between their down payment, what they pay up front when they execute it, and any equity that they have paid out over the term of the land contract, once that reaches 20% of the purchase price, at that point in time, the seller, if the buyer defaults, the seller has to file a foreclosure action as opposed to a forfeiture action, which is much like an eviction.